I was questioning a doctor in a medical malpractice case, and the attorney for the hospital kept objecting over and over and over again. Was there anything wrong with that? Actually, in this case, there was. Would you like to learn why? Come join me on this walk along the beach as I share with you exactly what the problem was. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. My client had brought a lawsuit against a hospital and hospital staff. For what? For improper medical care that she received while she was a patient at this hospital. Now, during the course of the lawsuit, I had an opportunity to question the different doctors who were involved in her care. One of those doctors, a very well-known prominent doctor, was no longer employed by the hospital. So what did I do? What I did was I had to serve something called a non-party witness subpoena, which means since this doctor was no longer employed by the hospital, the attorney for the hospital gave me their last known address. Then I take that address and I prepare a document called a non-party witness subpoena, which basically says you are required to appear for a deposition, and in this case it was a Zoom deposition, on a particular day at a particular time on a Zoom call. And now it involves this particular patient. Now, we took that document and then we had someone called a process server deliver it to the doctor who lived at this particular address. The doctor then went ahead and reached out to the attorney for the hospital, and they said, you know what, since the doctor is no longer employed, we are going to provide you with separate counsel, which means we're going to give you a different attorney than the attorney who represents us in this particular case. And that's what they did. So now, in preparation for my questioning, the attorney who represented the doctor asked me for a copy of the medical chart, my client's medical chart, which they are entitled to look at and they're entitled to receive, certainly in preparation for my questioning. And that's exactly what we did. I gave them a copy of my client's record. Now they have an opportunity to go ahead and review it, and the doctor can see what it was and refresh his memory about what it was that he did many years earlier. And then we go ahead and schedule the doctor's deposition. And in case you don't know, a deposition is a question and answer session that takes place typically in pre-COVID times in the doctor's attorney's office, and in COVID times it takes place on a Zoom video call. Now, I am there as the attorney who represents the injured patient, the doctor's attorney is there, and the attorney who represents the hospital is also on this call. Now, anybody else there? Actually, yes. There is a court stenographer there who is going to record all of my questions and all of the doctor's answers. The doctor's answers represent his sworn testimony, and, in case you don't know, it carries the same exact weight as if he's testifying in front of a jury, in front of a judge, in court, at the time of trial. But in this case, this is a pretrial question and answer session, what we call a deposition. Lawyers also call it an examination before trial. Okay, so what's the big deal? So here's the big deal. Now, when I ask the doctor questions, any objections that the doctor's attorney has, the doctor's lawyer is going to say objection and briefly tell me what the objection is, whether I didn't ask the question appropriately, whether I need to ask a different topic, or whatever objection the attorney has with my particular question or topic, the doctor's attorney will voice that objection. Now, here's something else you should know. In almost all instances, the doctor is required to answer my question. That means I can ask many questions of this doctor, all relating to the care and treatment involving my particular client. And now, here's the problem. The problem is that in a number of questions that I asked the doctor, the attorney for the hospital raised an objection. Not the doctor's attorney, but the attorney for the hospital. Now, you might be thinking, okay, what's the big deal? The big deal is that every time this lawyer for the hospital raised an objection, now he voiced his objection, which he's supposed to do briefly. He's not supposed to make a speaking objection in order to influence the witness's testimony. And now, once he made an objection, the doctor's attorney piped up and said, you know what? I like that objection. I'm going to make the same objection. So basically, she would parrot everything that the hospital attorney was objecting to. And now I'd have to re-ask my question or rephrase it or move on to a different topic. So why was that a big deal? It's a big deal because the hospital attorney kept objecting over and over and over again. I'll give you an example. There were a number of instances where I asked the doctor to give me his opinion about the care and treatment that he provided to my client. And if you don't know this, I am permitted to ask the doctor hypothetical questions. What would you have done if the following things had already occurred? What would you do if you found the following things? Would you agree, doctor, that good medical care would require that you do A, B, and C if the following clinical signs and symptoms were present? And now the doctor's going to either have an opinion or he's not going to have an opinion. If he has an opinion, I want to know what it is. So, in this particular case, I asked the doctor, if you had known about these things and you had been the one treating this patient hours earlier, would your treatment have been any different? Objection! The hospital attorney yells out. You're asking for an expert witness opinion of this doctor who happens to be a non-party witness. Now, what does that mean, a non-party witness? It means he's not a party to the lawsuit. It means we did not actually sue him directly for causing any of my client's harm and injury. Instead, I want to know certain factual information from this particular witness. He was involved in my client's care. He was present after certain things had taken place. And I want to know about conversations that he had with other physicians. So I'm entitled to ask him everything factually about what he remembers and what's contained in the medical records, as well as asking him to explain his understanding of certain things in the medical records by other physicians. All right, so let's get back to the title I raised in this video. What's the big deal? Why is it such a big deal if the attorney for the hospital keeps objecting over and over and over? I'll tell you why. The attorney for the doctor, most of the time, had no issue with certain questions and certain opinion questions I was asking him, and was ready to allow the doctor to answer those particular questions, which is exactly why I wanted to question this doctor to begin with. However, now that the attorney for the hospital was making an objection, and now stating his reason for the objection, the attorney for the doctor says, you know what? That makes sense. I'm going to object also. And I'm not going to allow the doctor to answer in the way that you asked this question. Which meant, okay, now I have to try and rephrase the question to make it more general, because I'm allowed to probe this doctor's knowledge of medicine. I'm allowed to ask him questions about the standard of care. I am permitted to ask him questions about his own opinions about what went on with my client. But the moment I start asking about opinion questions about whether treatment rendered by other doctors at the hospital were inappropriate, all hell breaks loose. Everybody starts objecting at that point. Objection, objection, you can't ask him that, you can't ask him that. Now here's an important distinction. In a medical malpractice lawsuit, where we have gone ahead and sued the doctor whom you believe caused you harm and injury, and we actually name that particular doctor, in a deposition, I am permitted not only to learn about what the doctor's knowledge of medicine is for this particular patient, I am permitted to ask this doctor opinion questions, and I'm permitted to ask him about the standard of care. I can ask this doctor opinion and expert questions. Why? Because he is considered a medical expert, regardless of whether we believe he did something wrong or not. So the law permits me in New York the opportunity and the ability to ask this defendant doctor, the doctor who has been sued, to ask him questions about his expert opinions, ask him about whether or not he violated the standard of care, ask him whether the patient's outcome would have been different had he done certain things differently. I am permitted to do all that. And the distinction here is the person that I was questioning was not a defendant, meaning we did not sue this guy directly because we had no reason to do so. We didn't believe that this doctor caused my client harm or did anything wrong. Instead, my goal was to try and learn as much as possible about his involvement, to learn his reasoning for doing what he did, and to see if he remembered or recalled specific conversations with other physicians at the time that this was going on. Now, can I ask the doctor opinion questions? In certain cases, yes, I can. Can I ask him expert witness questions? That's a gray area, and many defense attorneys would say no. There are different ways to phrase the question to try and obtain an expert opinion from the doctor without coming right out and say, "Doctor, do you have an opinion with a reasonable degree of medical certainty as to whether the treatment rendered to my client at this particular time violated the basic standard of medical care?" Objection! That calls for an expert witness opinion. I'm not allowing him to answer. Why? Because he's a non-party witness. But if I rephrase the question and say, "Doctor, would you agree that a patient who presents to the hospital with the following symptoms, good medical practice requires that you do A, B, and C?" And now I can take him down every step of the way as to what our experts have determined to be good medical care and practice. And I might be able to get an answer that way. So why do I share this quick information with you? I share it with you because this was an interesting dynamic where the hospital attorney, basically his objections would trigger the doctor's attorney's objection, where otherwise she was not going to object at all and was going to allow the doctor to answer those questions. So it created a little bit of a roadblock, but in most instances I was able to get around it by rephrasing my question, by asking it in a different way that alleviated their concerns about the specific question I was asking. You know, I realize you're watching this video because you wanted to see the beautiful scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.